Justice Mendoza.
I defer to Justice Abad.
I call your attention to the provisions of the RH law concerning reproductive health education for adolescents. Adolescents are kids from 10 to 19 years old, correct?
Yes, Your Honor.
Under Section 14, the state shall provide age and development appropriate reproductive health education for adolescents, correct?
Yes, Your Honor.
In fact, the law authorizes the Department of Education to prepare a reproductive health curriculum for public schools. That's right?
Yes, Your Honor.
That private schools may adopt.
Yes, Your Honor.
These lessons in reproductive health would be integrated into regular subjects like social science, correct?
The law doesn't say that, Your Honor.
Well, it says to be integrated in the regular subjects.
It doesn't say that in the statute, Your Honor. I'm sorry.
So in subjects that are part of the regular curriculum, the secular subjects.
What the law states, Your Honor, is this. The Department of Education shall formulate a curriculum which shall be used by public schools and may be adopted by private schools. How it will actually be operationalized will have to depend on the Department of Education. But because this is a facial challenge to the statute, we're bound by the statute only and not by what the Department of Education will do later on once the law is operative.
It says here, and integrated in relevant subjects. It will be into the teaching of reproductive health education will be integrated into relevant subjects.
Let me continue the statute, Your Honor. Relevant subjects such as, but not limited to, values formation, knowledge and skills in self-protection against discrimination, sexual abuse, and violence against women
that's
and
what
children.
constitutes the reproductive health education that will embrace those things that you're enumerating now.
Yes, sir.
But these things will be incorporated in, for example, social science. It will be incorporated in health or Filipino or such secular subjects. You don't know?
I don't know, Your Honor. But
okay,
what
well,
I know is that it will be formulated as part of the curriculum.
That's my reading of it. That it will be, and I've read a lot of modules they gave out, and they're integrated into regular subjects. So,
well,
anyway.
we cannot say they have been integrated, Your Honor, because the statute has not yet been implemented. In fact,
well, that's what the statute wants. And I'm not saying it's now integrated. I'm saying that it will be integrated.
it will
according
be, yes,
to
sir.
this law. Okay?
Yes, sir.
Now, and therefore it is implicit that attendance in reproductive health is a condition for graduation. It is a subject in public schools, and it is a condition for them to pass through their schooling, correct?
I would suppose so, Your Honor.
Now, based on Section 14, paragraph Q of the RH law,
14 paragraph.
reproductive health education covers values formation, self-protection against discrimination, sexual abuse, and violence against women and children, women's rights and children's rights, responsible teenage behavior, gender development, and responsible parenthood. But none of these are, of course, objectionable, as far as I can see. And
That's what we're saying, Your Honor.
And they're actually being taught in the public schools from my reading of their curriculum. Do you agree with that?
I'm not sure if they are already being taught, Your Honor.
Well, the subjects that are mentioned are
My
part of other
focus, Your
laws,
Honor,
actually.
is on the statute and challenges
So, anyway,
to its
my question is,
constitutionality.
actually, what is new in Section 14 is that it also seeks to address the problem of teen pregnancy. Actually, this used to be the sole concern, when during my time, the sole concern of the affected teenagers and their families. But for some reason, the state would now want to have a hand in the problem, correct?
I don't know what is new in the statute. All I know, Your Honor, is that
No,
there
the
is a
statute provides
enumeration.
for. Well, I think that's one of the presentations of Senator Pia, that this is one of the problems, teenage pregnancy.
Yes, Your Honor.
That this
We,
law
we
is
are
trying to
limited
solve. You
by our
disagree with her?
analysis.
You disagree with that statement?
What I'm saying, Your Honor, is that we are limited by our analysis.
No, the law mentions teenage pregnancy.
Yes, sir. It will be included.
So one of those concerns. So now, so the solution, well, apparently, it cannot be helped that a number of young girls engage in sexual relations with their age groups without taking precaution, and so they become pregnant. Correct?
Your Honor, is that a constitutional challenge?
No, don't ask me. I'm asking you. Don't ask me.
My answer,
I
Your
ask
Honor,
if
is
you
that
agree with me or not.
my answer, Your Honor, is that concern is irrelevant to the facial challenge of the petitioners here.
No, that is one of your arguments. We will consider that, but assuming it is
Yes,
not,
of course.
I'm assuming that it is relevant. So don't assume that it is relevant, because
I'm not, Your
precisely you offered arguments to defeat the spatial challenge, so we can discuss it on that way. Do you agree?
Yes, Your Honor, and I'm just following the line of our argument.
Don't tell me these things. So, because you yourself concede for argument's sake that there's a lot of arguments. So I'm making those arguments. Now, so the solution that the RH law offers is to teach adolescents how to avoid getting pregnant when having sexual relations. That's one of the purpose of this law. You agree?
It is one of the range of solutions,
Yes. Now,
menu of solutions
do you
that are
know
available.
at what age boys can cause pregnancy and what age girls can become pregnant?
Puberty, Your Honor.
Well, that will be around the ages of 11 or 12. The beginning of puberty. That is about grade 5 or grade 6, from what I see.
I can provide you, Your Honor, with a scientific explanation in our memo.
No,
I'm not a doctor, I'm not a specialist
No,
on
just
that question.
so that would be the age and grade appropriate, because I understand this education is age appropriate. No? That would be the age appropriate for learning knowledge and skills in safe sexual relations. That's right.
I suppose that would be one of the potential subjects in the statute.
Now, would you know the latest figure in the number of teen pregnancies in 1 year?
No, Your Honor.
Well, my figure shows that there were 196,000 teen pregnancies in 1 year in 2009.
Your Honor, we will try to verify that and submit an answer
anyway,
in the
I've seen
memorandum.
it. So, 196. Show it in your memorandum, but meantime, I'll assume it because I look at it. 196,000 teen pregnancies in 1 year. You can correct me later on.
Okay.
Now, based on these statistics I have from the NSO, there were 9,699,000 adolescent girls in the country in the following year, 2010. This means that roughly 9,503,000 adolescent girls in 2010 held out and did not get pregnant, as against the 196,000 girls who did. So what is the sense in teaching both male and female adolescents, which in the statistics number about 19,845,000 in all, knowledge and skills in safe sexual relations because of the erroneous behavior of those 196,000 adolescent girls? Because the downsides of teaching safe sexual relation to adolescents are based on what's happening in the other countries. Sexual perversion and promiscuity and weakening of the institutions of marriage and family. In the U.S., people don't get married. In Singapore and other places. And family that plague the countries which have promoted and practiced safe sex. would the government risk such enormous downsides for the sake of the few who got pregnant?
Your Honor, that is a question within the realm of discretion of the legislature. I'm sure that has already been considered by the members of Congress.
Reasonableness and arbitrariness is within the scope of constitutionality.
So what is the constitutional
So,
challenge,
well,
Your Honor?
Well, reasonableness and arbitrariness and oppressiveness.
Of what, Your
Now,
Honor?
should not the government instead help these pregnant teenagers cope by providing them and their children with shelter and counseling rather than put to sexual orientation 19,800,000 of our adolescents?
Number one, Your Honor, those responses are not exclusive. Number two, again, those are policy concerns of the legislature, not constitutional questions.
All right, that's your best. Now, would you think that all parents would agree to have their children taught knowledge and skills in safe sexual relations from the age of 11 or 12? Do you think parents will agree to that? All parents?
I don't know, Your Honor. I'm not a parent.
Well, there will be parents who will not agree, precisely why we have some who are opposing this. Now, the propriety of consented sexual relations between two unmarried persons from age 11 or 12 remains an issue that involve parents. Do you agree?
Yes, of course.
Because children at those ages remain under parental authority, correct?
Yes, Your Honor.
To some parents, such kind of sexual relations can be immoral. Do you agree?
I suppose, Your Honor.
Who has the primary right in the rearing of the youth for the development of their moral character?
The Constitution, Your Honor, points to the parents.
To the parents precisely. The state's role is merely secondary. Primary means to say it's the parents' right. Now, I have some excerpts from modules in sex education prepared for public schools many years back entitled Kaalamat Informasyon sa Katawat Kalusugan Nating Youth, or Kikay Kit. They call it Kikay Kit. These were patterned after American models. One says, the sexual urge is a natural feeling of the body that should be fulfilled. I repeat that. The sexual urge is a natural feeling of the body that should be fulfilled. And it continues, it is the body's normal response to gratify or to express physical desire. Well, this is like saying to those 12-year-old kids that you will teach that you like sex, you have the right to do it, but use contraceptives. This teaches self-indulgence. Would you agree?
Your Honor, those materials are irrelevant for purposes of this litigation. If I may, I'd like to read to you the statute.
No.
Provided that flexibility
I'm
in
not
the
asking you whether it's
formulation.
relevant or irrelevant. That is, I'm asking you if this constitutes self-indulgence. Do you know that?
Your Honor, are you asking me to agree with your conclusion or to disagree
No, answer
with
the question first
material
before.
that you have read?
You answered the questions first because I'm the one asking you this question.
Yes, of course. I'm sorry, Your Honor. Again, let me manifest, I don't see the
So you-
materiality of those materials with respect to the constitutionality of the statute.
All right.
The
So I
Department
ask
of
you-
Education, Your Honor, may very well reject all previous materials and start all over again. In fact, I think the DepEd has begun just that with the participation of faith-based organizations.
Well, that's your best point. Now, Rod, may I ask you, does the RH law require public schools to provide parents with advanced copies of the lessons they will teach their children from age 12 concerning, or age 10 concerning sex? Does
The
law provide-
statute, Your Honor, does not say
Does
that,
not. Now,
although
does the RH law require public schools to get the consent of parents before indoctrinating their children with values that acknowledge a natural right to indulge in sexual relations?
I'm not sure about the word indoctrination,
Well, the
Your
law,
Honor. That's a
is
rather
it- is
strong
that-
term.
Well, I'm asking you if the law provides for
What the law provides
Securing
for, Your
consent
Honor,
from
is
parents.
that there's flexibility in the formulation of the appropriate course content, and school officials and other interests
Now, yes, the parents'
shall be
consent
allowed
required.
only after consultation with parents, teachers,
the
community
consent
associations.
of the parents of the children. Are their consent required for attendance in sex education?
For
under the
attendance. If it is going to be part of the regular curriculum, it will be treated as a regular
Now,
subject.
Is parental consent required before children are taught that sexual relations outside of marriage or absent a loving relation is good for them or their bodies? You don't know.
I don't think the RH law says that, Your
In other
Honor.
words, the Department of Education has a far superior right because it did not ask to have to ask for consent. In the public interest, this points from the public interest, over the rights of parents to the sexual education of their children that affect family values. That's your position, actually.
Again, Your Honor.
That the Department of Education has a superior right as far as sex education is concerned.
No,
than
Your
the
Honor.
parents.
In fact, what I said in my opening statement is that it is not exclusive, the right of parents. And the Department of Education
Yeah,
is
that's your
simply
point.
through
That's
the
what
public
I'm saying.
curriculum. Yes.
Well, I'll go to another point. I call your attention to section 23,
23.
paragraph A, number 1 of the RH law. It prohibits healthcare service provider from intentionally providing incorrect information regarding programs and services on reproductive health, correct? Is that correct?
Yes, Your Honor.
In this connection, Section 9 of the same law states that hormonal contraceptives and IUDs are safe. Yes?
No, Your Honor.
So, Section 9
That is not what
it
Section 9
states that
says, Your
hormonal
Honor.
contraceptives and IUDs are safe because it is safe like the other things. It says. So it does not say that.
It does not say that, Your Honor.
So
That
what
is
does
a
it say?
conclusion. Let me read, Your Honor, Section 9. The National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortifacient, and effective family planning products and
So
supplies.
from your point of view, that does not say that hormonal contraceptives and IUDs are safe.
No, Your Honor. It simply reiterates the function of the FDA, right, to ensure that
So I will tell you, from the
hormonal
point of view of the
contraceptives
law,
are safe, legal, and non-abortifacient.
so I'll ask you directly, from the point of view of the law, are hormonal contraceptives and IUDs safe?
That is for the FDA to determine, Your Honor. What the law is saying is simply
Does
only...
the law say? I know. I'm looking at the law, and I've not found there a provision that says that the Food and Drug Administration is the one to determine whether they are safe. Only
I'm
they
sorry,
are
Your Honor.
not
There is a
abortifacient,
council.
but rather whether they are safe. That's not there.
No, Your Honor. Let me correct myself. There is a council, apparently, that determines what types of drugs go into the National Drug Formulary. And it is that council that determines whether or not they will be included. But the FDA also, Your Honor, has the function to determine which types of drugs are safe, legal, and non-abortifacient. In fact, this statute imposes the obligation on the FDA to ensure that hormonal contraceptives and IUDs are safe, legal, non-abortifacient. And that is because there are already, as was mentioned by
how is
Senator
it now?
Pia
Where does
Cayetano,
it stand? Well, assuming it's FDA,
it provides a
does
standard.
it provide are hormonal contraceptives and IUDs safe?
I
As
think,
far
Your
as you
Honor,
know.
that is the wrong question for purposes of
No,
reading
well,
the
you said that the
statute.
FDA has looked at it. That's the position of the government?
The position of the government, Your Honor, is that Section 9 creates a standard.
No, I'm asking you whether it's true that hormonal contraceptives and IUDs are safe. That's
If they are allowed by the FDA.
Are
Because
they-
the
so-
FDA, Your Honor,
So I ask
is
you,
the,
have they allowed by the FDA?
They have been allowed by the FDA,
okay.
Your Honor.
So-
if
so
I
they
may
are
tell you, Your Honor,
so they are safe.
hormonal contraceptives and IUDs are already available in the private market ever since
All right,
1966.
so based on
Since
official...
1966, they
So-
have been allowed in the private market,
All right,
Your
so
Honor.
based on official position, these are safe.
Those that have been allowed by
Are
the
safe.
FDA.
Okay, now. So if a doctor tells his patient exactly the opposite,
Okay.
namely that these things that were approved by the FDA are not safe, in their honest professional opinion, the doctor will be giving the patient an incorrect information?
The statute says knowingly withhold
Well,
information.
he knowingly.
to restrict.
He knows that the FDA ruling is that it is safe, but he says in his opinion it is not.
Then that is his opinion.
So, well, will he go to jail for it?
Of course not. He's
No,
making
he
an
tells his
opinion.
patient. That's what the government says. Well, which one is the correct information? What the FDA says or what the physician says? They are opposite positions.
Your Honor, when the FDA says it is safe, that means it can be used. That based on a risk-benefit calculation that they have made, it can be used for private purposes or public
So the
purposes.
doctor-
in the same way, Your Honor, that
So
it is
the doctor
available
will
in the
not go to
private
jail
market.
for saying that they are not safe.
If in his opinion, it is not safe because the risk-benefit for purposes of application to a particular person is
No,
not
just
safe, then
somebody
that,
just asked, he's not examining him yet, but consulting him, and he says, I do not consider that safe for anybody. Will he be liable under this law?
I don't think so, Your Honor.
But so that information that he gives is correct information.
That is opinion, Your Honor. This refers to information. It has to be factual.
Information.
If he says that the FDA is wrong, then he can be subjected to prosecution because he's going against the official statement
so
of
if
the
a
FDA.
physician disagrees with the finding of the FDA, he will go to jail and tell his client his patient about it. He will go to jail.
Allow me to read you, Your Honor.
No, that's
the
what you're
full
saying.
Statement. Okay.
That's what you are saying.
What the RH law, Section 23, Paragraph A, Number 1, prohibits.
Don't go to that. I was asking
Knowingly
you-
withholding information, restricting dissemination, intentionally providing incorrect information regarding programs and services on reproductive health. That is his opinion with respect to hormonal contraceptives, Your Honor. Nothing to do with
he disagrees
programs
with the
and services on reproductive health, including the right to
FDA.
informed choice.
He disagrees with the FDA and tells point blank to somebody ask him and says, no, I disagree with the FDA. Those contraceptives are not safe.
In the course of a patient-client relationship, doctor-client relationship goes against a finding of the FDA, then I would say the prosecutors can think about it.
So there's well, that makes this law vague. If people have to, by just reading it, will not be able to know whether a crime has been committed or not.
Your Honor, that's a problem with the facial challenge. We are in the realm of speculation. We're looking for ways to find the law unconstitutional. And I don't think that is the function of the court. The function of the court in a facial challenge is look simply at the correspondence between the text of the Constitution and the statute.
All right. My recollection is that both
Your Honor, your concerns are appropriate for an as-applied challenge, which has
Right.
no
Let me ask-
preclusive
let me
effect
ask
on
you-
the dismissal of
Let
these
me ask you
cases.
another question. My recollection is that both Congressman Lagman, correct me if I'm wrong, and the Universal Healthcare Study Group, on whose paper Congress relied on, according to you, hold the view that life of the unborn child begins only from the moment of implantation of the embryo on the uterine wall. Is that view correct or incorrect information under the law?
Insofar as a doctor-patient relationship is concerned, I don't even know how that would arise, Your Honor, in a doctor-patient relationship.
No, it will matter because abortion is prohibited, and if the opinion
And the
is that there's
statute
no
is-
abortion
is
before
clear about its
implantation of the
policy on
uterine.
abortion.
That
Abortion
makes
is not
That
allowed.
makes a difference in my mind.
Your Honor, the statute is very clear.
So you don't know the answer. No, you just tell me if you can answer it or not. I'll be contented if you cannot answer it.
What I'm simply saying, Your Honor, is that the statute is quite clear.
Now, many Catholics tell us that contraceptives kill the unborn that God creates out of His own image. Would you consider that an incorrect information?
Your Honor, that is a valid statement by a citizen, because a citizen
I'm
is
not asking
entitled to
if
free
it's a valid
speech.
statement. I'm asking you if under the law that constitutes incorrect information if a doctor tells that to a person seeking help.
Again, Your Honor, I want to hear your question again, Your Honor, if I may.
Many Catholics says that contraceptives kill the unborn that God creates out of His own image. Would you consider that an incorrect information from the point of view of this law?
I would consider it, Your Honor, a citizen's opinion.
Not information, no, but
Yes, of course.
But it's a doctor
citizen,
saying-
Your Honor, is entitled to a wrong opinion.
well,
That
so
is
it's
called
an
free
opinion
speech.
if a doctor tells that to his patient. It's a neutral opinion. So there's no crime committed.
The requirement, Your Honor, is for the doctor to provide access to RH information and services. If the doctor is
No, I'm just telling you
a
this.
dogmatic
I'm
Catholic
limited to
or
this
a true
particular.
Catholic, then
Don't
his
go into that.
obligation
I'm
is to
limited.
conscientiously object and refer.
I'm limited to this particular circumstance or situation.
But, Your Honor, we cannot invent factual situations just so we can find some
We're not inventing.
unconstitutional portions in the statute.
evidence, you
This is
can
a
ask
facial
hypothetical
challenge.
questions. It's
And in
okay.
a facial challenge, let me just
Hey,
repeat
let me finish.
jurisprudence, Your Honor.
We can ask hypothetical questions. You know that. So that's not inventing.
In a
We can
facial
ask
challenge,
hypothetical
Your Honor,
questions
all
to
that we
check.
need to find is a constitutional application of the statute. And if the statute has a constitutional application, that is a knockout argument. Respondents are entitled to a dismissal of the opinion. If there
Yeah,
are
I know
possible
that.
unconstitutional
You've been
application of the
repeating that
statute,
argument, but
that
I
will
said-
have to be done in an as-applied challenge.
You should not have presented arguments that assume for the sake of argument that
But,
these
Your
can
Honor,
be raised here.
all our
did.
arguments have jurisdictional underpinnings. That is exactly what we have been trying to say.
That's still the issue. It's not settled here that is the case. You know.
Your Honor,
don't
we
insist
are
on
not
that.
trying to reinvent the
Don't
wheel.
insist on that because we can ask these kinds of questions because we can ask hypothetical questions and test your thesis against these hypothetical
Yes, of course,
questions.
Your Honor. And our answer always has an underlying assumption.
Yeah, we know that.
An
We are
argument.
aware. But
That
that
the
is
court does not
unsettled.
have jurisdiction.
We have not made a ruling that these are invalid facial challenges. We have not made a ruling.
And we agree that you have not yet made a
So
ruling.
don't
But
use
we are
that
making an
against-
argument, Your
Don't
Honor.
use that against us when we ask you these questions, because that is not a settled matter. Okay. Now, suppose a doctor reads the result of the latest scientific and medical research, and this convinces him that the government's view on artificial contraceptives is not correct. He cannot tell that to his patients because he would giving incorrect information until the law is repealed.
I think, Your Honor, again, we're speculating, but assuming that there's that kind of a factual situation, what the law generally provides is for doctors to comply with the standard knowledge of their discipline.
Well,
If they knowingly
I gave
go
you a
against-
specific. Don't stray away. I gave you a specific situation. I know those general principles. I don't need that. I'm giving you a general situation, a specific situation, and I'm asking you whether that constitutes incorrect information. You can tell me it's not, or it is.
Your Honor, that would depend on the prosecutors if they want to consider it in an as-applied matter, once the law is operational.
So just from reading of the law, you will not be able to answer it.
Of course not, Your Honor.
Well, that makes that law vague. It's a criminal provision, and if you cannot answer it...
No,
in
Your
the
Honor.
case of
My
Democrat,
answer
what
is
do you
simply
think?
that if any challenge will have to be made against the law, it will have to be made as applied, so that we have concrete facts involving real parties with real interests.
Right. Let us go to the conscientious objection portion of Section 23A, number 3. Except for conscientious objection, would the doctor have any valid ground for refusing to provide the services asked of him under Section 23A, number 3?
Again, Your Honor.
Except for conscientious objection. That's an exception, huh? That's an exception.
Yes.
Not, would the doctors have any other valid ground for refusing to provide the services asked of him under Section 23?
If his objection is religious, his only objection would be that of a conscientious objector.
No other valid ground. No other valid ground for
I don't know, Your
refusal.
Honor, whether in the medical profession there are other valid grounds. But insofar as
law
religious
is
objection
concerned,
is concerned,
There's none.
the ground is conscientious objection.
Okay. The conscientious objector has, according to Section 23, the option to excuse himself from providing the health care services required of him on account of his ethical or religious belief, correct?
Yes, Your Honor.
But he must immediately refer the person seeking his services to someone else who could do it, correct?
Within the same facility or one which is conveniently
Yes,
accessible.
well, that's good. Now, suppose the Catholic religion considers it a sin, similar to murder, to implant a copper IUD into a woman, since it would kill the unborn by preventing it from attaching to a womb atrophied by the toxic substance from the copper IUD. The RH law respects the right of the Catholic doctor, in this case, to refuse to do what his faith regards as murder, correct?
Yes, Your Honor.
But he has an obligation to immediately refer the woman to another doctor who would be willing to do it for her, right?
The law refers to another healthcare service provider within the same facility or
this
one
is a
which is
shortcut.
conveniently
Who's willing
accessible.
to do it? Yeah. Now, so if the law would excuse the Catholic doctor from committing what in his faith amounts to murder, would it be reasonable for the law to compel him to help the woman and show her how she can have her child murdered by another doctor?
Your Honor, you're assuming that the free exercise clause assumes that the state believes in the factual belief of,
Yeah,
in the
that's why-
religious belief of the
That's
objector.
why the state honors that belief, because precisely the state tells him, you may opt not to do it.
Your Honor, freedom of exercise has a fundamental underpinning, and that is respect and tolerance, not belief. The moment we enter that realm of belief, we are entering a territory which has led nations
but the
to
law
war.
itself,
The law does
honor
not.
the belief here. Ano? Talaga yan, di ba? The law says honors the religious belief.
Of course not, Your Honor. The law says it is respected.
Yes, it honors.
But the state doesn't
respects.
believe. It doesn't
What does
necessarily
it-
have to believe.
What does the law say exactly, you know?
The law uses the word respected.
Ethical or religious belief. Ano sabing walang belief na kalagay?
Shall be respected.
Oh yes, respect. What do you mean by respect? Respect means to...
It is entitled to
honor
consideration.
it, no? Not to compel. Precisely what he says, don't do it. If you don't like it, do it. Your religion prohibits it, let somebody else do it.
Exactly.
All right, so...
But the state doesn't say we believe in what you believe, because that would be
I
a
did not say
violation
that.
of the non-establishment
I did not say
clause.
that.
Which
You-
is exactly also why
You're putting
the
something
state-
into my mouth that I did not say. I did not say that the state should believe what the doctor believes. I did not say that.
But that's the
But
assumption
that
of
the
what you're
state
saying.
should honor or respect that belief. So
Yes,
that's
Your
what
Honor.
I'm saying. So what is your answer to that? That is your best answer?
There are several answers. Number one, Your Honor, This is in the context of a doctor-patient relationship. When a doctor assumes a responsibility, he has to perform the functions of that office. The conscientious objector proviso actually allows doctors to be unprofessional to the extent that they are allowed not to perform the functions of their office. As a compromise, they are given the right to refer the patient. Why? Because this happens in the context of a professional relationship.
But
If
medical-
I may give you an
you.
example, Your
I'll
Honor.
interrupt you. Medical practice, from what understanding, is the application of the science of medicine on the patients, medical practice. But you consider rejecting a patient and telling a patient to go to another doctor part of medical practice? What if you can show me a medical manual practice that says that is part of medical practice?
Your Honor, the requirement is for them to perform their medical functions, which is to provide RH
It does not
services
say
and
here.
information.
It does not say
If they
in the
have a
law.
conscientious objection to the statute, the law says they are excused, which is a grave concession
So-
on the part of the state.
Well, anyway, that is your submission.
Yes, of course, Your Honor.
Now, you cite the Ebra-Linag case concerning students who were members of the Jehovah's Witnesses. They refused to salute the flag, right? In
On
this
what
case,
page, Your Honor?
in this case, they refused to salute. That's in your comment. In this case, they refused to salute the flag, right?
Yes,
It's a very
Your
simple case. And for this reason, they were expelled from school, correct?
Yes, Your Honor.
But the Supreme Court said that the school cannot compel the Jehovah's Witnesses to salute the flag, right?
Yes, Your Honor.
That would violate, said the court, the religious belief that salutes are reserved to God, correct?
Yes, Your Honor.
The court said that the Constitution respects their religious belief not to salute the flag, right?
Respect, Your Honor.
Yes. It is the same here in the sense that the RH law actually respects the right of the Catholic doctor not to be compelled to implant, in this example, a copper IUD into a woman's womb because it amounts, according to his religious belief, to the murder of an unborn child, correct?
With one big difference, Your Honor. In the case of Ebra-Linag, the students were being compelled as citizens of the Republic. They were being imposed a civic duty. In the case of the RH law, the minimal compulsion, which is the duty
No,
to
I'll go to
refer,
that. I'll
happens
go to
in the
that
context of
later.
a professional relationship.
Well, I'll go to that later, no? But as the main thing is that they were not required, the doctors here are not required to do what ordinarily they should have done. No?
They are required
because
to
of their religious belief. Now, so the Constitution and the law respects the doctor's religious belief, right?
Yes, Your Honor.
But you invoke the court's ruling in the Jehovah's Witnesses case that the school authorities are not powerless to discipline their members if they commit breaches of the peace, right?
Yes, Your Honor.
By disruptive actions that would prevent others, namely their classmates and teachers, from peacefully saluting the flag and singing the national anthem. It's all right for you if you don't want to take part, but you have to allow the
They have
others
the right to remain silent,
enjoy.
Your Honor.
Okay,
Yes.
that's okay. Now, the Jehovah's Witnesses should respect the right of others by keeping quiet and not disrupting the flag ceremony. That's the ruling of the court.
Yes, Your Honor.
Keep quiet and let alone. That is the rule, correct?
Yes, Your Honor.
Now, in the case of the Catholic doctor, he should do nothing to impose his religious belief. Ayaw niyang maglagay ng ayaw, it's okay. But he should not impose his religious belief on the woman, correct?
By refusing to refer.
Yes. No, not to do the
Oh, Your Honor,
implantation.
that is what the statute says.
No, I'm not going to that
He
yet.
cannot transform his religious belief to make himself a positive impediment to access to RH services and information.
But like the
And that is
Jehovah's
reasonable.
Witnesses, the equivalent conduct for the Catholic doctor, it's you required, the court requires of the Jehovah's Witnesses, is to keep quiet and let alone. But here, the law requires the Catholic doctor to take steps positive steps to ensure that the woman is pointed to another place where she could get the IUD implantation she wants. In effect, the law compels the doctor to do more than just keep quiet and let alone. Correct?
Wrong, Your
Not
Honor.
just keep quiet and let alone, but do something else.
This relationship, again, Your Honor, if I may, in Abralinag, the relationship was between citizen and the state. A Jehovah's Witnesses who remain silent during the flag ceremony harms no one. And so the court says you can keep quiet, but you cannot be noisy, you cannot criticize people who are saluting
said
the
that
flag or
already.
singing the national
Don't
anthem.
repeat that. We said
But in
that
the
already.
context of a professional relationship, a doctor-patient relationship, not a citizen-to-citizen relationship, that doctor has a positive duty to perform something.
He is not his patient.
But he is.
No, he just came and said, I'm not going to do it for you.
That is his duty. The moment, Your Honor, a doctor enters a hospital or a clinic, that doctor wears a hat. And that hat tells to everyone,
that's
I
a
am
new-
willing to perform my
That's a
medical
new theory
functions.
on formation of...
That is the theory of the statute,
so
Your Honor.
Parang sa lawyer, kung gano'n, pag napunta somebody wants to be wants to consult, he is already a client. Well, we know
Yes,
that's
Your
it,
Honor.
no?
Which is why the more appropriate analogy is people versus Judge
So
Veneracion.
that is your answer. That
is
the
our
kind of
best answer,
relation
Your Honor.
that we have now.
Yes.
The law compels him at the pains of going to jail to get involved and help in the commission of what his religious belief regards as amounting to the murder of a child in order to satisfy the need of the woman, her partner, for sex without pregnancy, correct?
Wrong, Your Honor.
That is the exchange.
Again, Your Honor, those are astoundingly wrong assumptions about the operation of the statute. The duty here is a professional duty. If I were talking to a doctor as a citizen, that person has all the right in the world to reject my request for
By the way,
RH information and service.
this
But the
referral-
moment that doctor enters a hospital, wears a hat, assumes a responsibility, the law says you have to perform that responsibility. But the doctor says, no, I'm a true Catholic. And so the statute says, we are respecting that, but because you are a professional, we're imposing on you the minimal burden to refer. That is the theory of the statute, Your Honor. Because you are a professional, we will allow you to reduce your professional responsibility by not performing the task, but we will impose on you the secular task of providing RH access to information and services.
So, unlike
we are not
the-
allowing you to become a positive impediment to the statute.
So it's a case of not just keep quiet or let alone, but get involved in something that you consider a violation of your religious faith. To help someone get help to commit the murder that the doctor will not himself commit.
That is a
From
good
his point
opinion.
of view. From his point of view.
Yes, and the state
Okay, now-
says we stop at the point
Is,
where we recognize your conscientious objector
But these
status.
referral cases are not emergencies actually, because if it's an emergency like a bleeding woman, the doctor has no choice but to give
There
medical
is an
assistance
additional
already.
proviso in the
So
statute.
this is a non-emergency case. I wonder if you honestly think that a doctor should be jailed for not helping the man and the woman get worry-free orgasms.
Your Honor, my private opinion is irrelevant to the constitutionality of the statute.
Well, my final point. The law especially wants the poor to have the people full access to quality health care services, correct?
Yes, Your Honor.
In fact, Section 7 requires all government, maternity hospitals, and clinics to provide them with contraceptive supplies and procedures. Do you agree?
Not to provide, Your Honor, but to provide access if they want to.
Well, access.
This
we
is a
give it to
liberal
them.
statute, Your
How
Honor. This
can
is
you have
not a
access
compulsory statute.
How can you access supplies in government hospitals if you will not be given supplies?
You have to say yes first, Your Honor.
Oh, yeah, that's right. Now, would you have an idea of how many poor women are candidates for free government-supplied contraceptives?
None, Your Honor, but I'd be willing to provide you with the numbers.
Well, let us assume roughly 10 million, about half the probable number of women of child. Let's make it even, let's say, 8 million. A set of contraceptive pills costs about 500 pesos per month. That would be about 6 billion a year for just 1 million poor women.
Just 1 million poor women.
Yes, so 6 billion. Hormonal IUDs cost about 10,000 each, or about 10 billion for just 1 million poor women. The cheapest contraceptive is the copper IUD. It costs about 152 each, the price of a lunch. That would cost only 125 million pesos for 1 million poor women, and good for 5 to 10 years, according to some manufacturers. Indeed, foreign funding is available for this. Now, which of these, in your opinion, will our government provide free to poor women? Which of these kinds?
I think, Your Honor, that the government can choose to provide a full range of RH services and supplies and information. How?
The answer is the 125 pesos per piece copper IUD, because in fact that is what the government hospitals where people deliver their babies.
Well, that is the
actually
speculative
given.
answer, Your Honor, by
Well,
a citizen. If you want, Your Honor, we can provide you in our memo with
Yeah, you
the
give us a
numbers
memo,
by
no?
the DOH, for the DOH.
So it does not matter that according to the World Health Organization, copper IUDs steadily releases toxic or poisonous particles into the woman's womb to kill the sperm and atrophy the uterine wall for 5 to 10 years. It does not matter that these copper IUDs have harmful side effects. These IUDs are cheap now, and we are talking about the wombs of the poor women. Do you think that women of the poor have a fighting chance against the known harmful side effects of copper IUDs?
Your Honor, it's accessible even to those with money.
Well, really poor women don't have money for fare going to the doctor. Tell me, where will they get the money they need to cope with irregular bleeding during menstruation resulting in anemia, which is the common complaints on...
Your Honor, I'm not a medical doctor. I don't know whether or not all uses of IUDs
asking you
will
where
necessarily result in
Where the
bleeding.
money, where the oil?
All drugs, all devices
Well,
have
you should
potential
have-
side effects. And there's a statute, Your Honor, that says that the FDA is
You
put on
should have
notice with
conducted
respect
your,
to the
your
side
res-
effects of this.
We expected
these
you to
devices.
conduct your research and look at it.
Well,
Now,
of course, Your Honor.
where will they get the money for vitamins? This is the women of the poor. Our target is 8 million. Where will they get the money for vitamins and medicines they need to fight anemia? Which doctor will examine them for free, give them blood tests and other procedures for dealing with headaches, inflammation, and pain in the pelvic region, abdominal cramps, breast tenderness, and vomiting?
Your Honor, I
They
don't
have no
think
money for fare.
hormonal contraceptives and IUDs will be distributed like candies under the statute. These are prescription materials and services. And it would be unprofessional for a doctor to stop following up with a patient.
If these IUDs, copper IUDs are not removed, their wombs, the wombs of the women of the poor, would be receptacles of poisoned copper particles for 5 to 10 years. Do you think this
Your
will
Honor,
not cause permanent injuries to those wombs and eventually cause death?
I don't think we can test the constitutionality of the statute by the standards of an unprofessional doctor. I think we have to assume that our doctors in the public and private sectors will perform their task, that if they provide hormonal contraceptives or IUDs, they
But
will
these
follow
are,
up. Because that is part of the functions of their medical profession.
But these are accepted adverse side effects of these.
Then if these are
IUDs.
accepted side
We
effects,
are
then
talking
the
here
doctors
about-
are put
we
on
are talking
notice
here-
to supervise.
We're talking here about targeted 8 million poor women. would the government have the money to help 8 million women cope with side effects when in the first place it is money only for the cheapest kind of IUD and the most toxic to give to them?
Your Honor, the statute provides for full access to the full range of RE services, supplies, and information. It's not as if the only ones that will be provided will be the cheapest hormonal contraceptives and the most dangerous
The
IUDs.
government will give that. Now, before I end, may I ask Senator Pia Cayetano to check the information she gave us at the last hearing that the risk of cancer from hormonal contraceptives, grade 1, is the lowest risk and is equivalent to exposure to television, cell phone, or microwave oven, because a cancerologist told me that grade 1 is the highest risk classification for carcinogen. The exposure to television, etc., belongs to grade 2B, which means that the claim that they cause cancer has not been proved. So please include that, the result of your query. I just want to check, in your memorandum. Thank you.
Thank you, Justice Abad.